Is the issue.
Any of the bills that are in for this season?
Yes.
Notify the photo?
Mr. Mackey, I don't believe the complaining witness is here from Mr. Mackey.
Mr. Mackey,
That is correct.
Yes, ma'am.
no witness. Have you been in contact with the witness?
Your Honor, the witness was here last week, but I believe that in the interest of justice will not the people in Ollie. I don't believe that she'll be cooperative moving forward.
Oh, the witness was here, but you don't believe she's not willing to.
She made it clear that she would not be coming moving forward. That's correct.
So you're on Latoya Scott is here.
Take a Molly from that. Okay. I'm all set. Okay. On the record in the matter of the people of this state of Michigan versus Corey Buffkin, 25-03118, appearances.
Yeah, Bucky here for the people motioning to practice in their court rule 8.120 under the supervision of Ms. Fortuna Gill. She is currently not in the room, Your Honor.
Was she outside the room?
I think she was
He is currently releasing the witnesses.
Yeah, she's right. Ms. Fortuna Gill is president of the courtroom now, and Ms. Fortuna Gill has really advanced in the last couple of weeks. She went from a couple months from not having a P number to now supervising. Isn't that crazy?
That is
Doing really well.
Goes really quickly, huh? Goes really quickly. Okay. I don't know what's going on in the prosecutor's office. They probably need to hire, probably.
I don't have the mental energy to even think about
Yes,
it.
Your Honor.
I'm set
Yes,
to
we
be here
do.
for a couple months if that makes you feel better.
You said what?
I'm set to be here on Mondays for a couple months if that makes you feel any better.
I mean, I think for the last year have had someone be supervised.
You counted it up, Your Honor. In the last calendar year, this is my 8th prosecutor.
No, literally, I think I'm getting the short end of the stick.
I'd love to be assigned here, Your Honor.
Yeah,
She did that.
yeah, I don't know why they won't assign anybody to my courtroom, but obviously we flow regardless, so.
I think the specialty courts get
fine.
priority for permanent assignment,
It'll be
and
fine.
some judge floors are left looking.
Yeah, well, I have a specialty court starting in 2026.
You make a
so
good point, you do. That's
There's
true.
that.
I will let my office know and let them know that my interest to be assigned here remains.
Thank you. Okay, this was a final pretrial for an assault and battery. We have a witness here.
Yes, Your Honor, we do.
And I apologize, Your Honor, I don't think I put myself on the record. Assistant Public Defender Lawrence Sutter, on behalf of Mr. Buffkin, he is standing to my right. It is my understanding that the complaining witness was here today.
Yes.
There is, I don't really call it an offer, Your Honor. There's a request for restitution in this case with the killer agreement to no upfront jail. At this time, for now, we'd like to continue to trial.
It doesn't sound like an offer. It's plea to the charge with pay restitution and no upfront jail is what we would do anyways if he was found
It's an
guilty.
illusory offer, which is why I said I hesitate to call it an offer, but
Agreed. Okay, so why would you like to go to trial too? Okay, so you want to continue to trial? This matter is scheduled for trial January 27th at 8 a.m. We'll get you a new notice to appear. Did your witness leave or are they still here?
They're still here.
Okay, wonderful. So they'll be advised as well. I don't know what the priority case number is on this. I'm assuming this will run on the 27th, but
it's a pretty high one. There might be others earlier, but I'll figure that out as we go along.
sounds.
Service up the 28th, Your
No,
Honor.
27th. Oh, there is another one that's set that's older than that one. So there's a chance this may get reset on that date, but we'll know closer to that date. So you should remain in contact with your attorney. The prosecutor should remain in contact with their witness so that if we know for certain that the other one is likely to go, you're not wasting your time taking off work or the victim taking off work, okay? I will get you a notice to appear. Do you have any questions at this time? Any additional matters for the record?
Those are the people.
Nothing further.
Thank you. You're all set. This is the state of Michigan versus Noah Dakota Kane, 25-02612, appearance please.
Anna Buckingham for the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Kane, who is approaching council table now.
Was the date and the time scheduled for a final pretrial for an assault battery? We have a witness here.
Yes, Your Honor, and people have a witness, and it's my understanding that we would like to set for trial.
That's correct, Your Honor. There's no offer on the table at this time. Or I've been advised there's none.
There's no offer extended, correct?
That's correct.
Was there ever a trial set for this?
No, I don't think so. Your Honor. I believe we were advised the January books weren't open yet at the first pretrial.
February 3rd at 8 a.m. February 3rd at 8 a.m. for trial, okay? You can take your hands out of your pocket. Okay, so that you'll appear in person for that. The victim will appear in person for that as well. Do you have any questions at this time? Any additional matters for the rest of it?
Nothing from the people.
Nothing further. Thank you.
We'll see you February 3rd, so. Green is in custody.
No, Your Honor, he's not. They keep bringing his father instead. He is here in person.
So they have the same name, is that what's going on?
They absolutely do, yes. But
They can't figure out the birthday. So
Every time, Your Honor. Every few weeks I check in with Willie Green Senior or Junior.
from the record in the matter of the state of Michigan versus Willie M. Green, 25-02421. Yes, please.
Anna Buckingham for the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Green, who is approaching council table now, and if I may approach.
Yes. Mr. Green, what year were you born? What year were you born? Okay, today was the date, the time scheduled for a final pretrial. This was for originally charged child abuse fourth. I have a offer for the defendant to plead guilty to an amended count of domestic violence first. Is that accurate?
That's correct, Your Honor, along with
The remaining, or the original charge, no contact with victims while on probation. And agree to sobriety, outpatient treatment. Or recommending dismissal of PA 53, I don't know.
It's for being at the allegedly being at the protected address.
The allegations is that he entered the protected address after being advised by Magistrate Magistrate Faulkner, that he was not to be at this address or within 2,000 feet of the protected party, that he entered intoxicated, which would actually be 2 violations, not 1. If true, and began yelling, entered into the protected party's bedroom, sat down, took off running when the police were called. I don't know how that, if true, would make him a good candidate for a dismissal of the P53 and probation. Because that would indicate he doesn't follow court orders.
And if I-
Your Honor, after speaking to the victim's mother, it's some people's understanding that a lot of the issues arise from alcohol abuse. There's also an interest in protecting the defendant's son, who's the alleged victim in this case, from having to come and testify. That's kind of the purpose behind this, is the victim really just wants the defendant to
Get some help.
address this issue.
I can appreciate him wanting him to get some help. That doesn't usually work, because who has to want to get help for it to work? You can uncross your arms. So, it's up to you if you want to get help. If you don't want to get help, we can just do straight jail time. You want help? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury? I can't hear you.
Yes.
You can put your hand down. I have an advice and rights and plea information sheet. There's 2 pages. Is this your signature? You understand the rights here?
Yes.
You understand that you would have to give up all of these rights if you wanted to plead guilty to the amended charge of domestic violence first offense? So that means you have the right in this matter to the presumption of innocence. You're innocent until proven guilty. You have the right to maintain your innocence and take this matter to jury trial, at which time the prosecutor would be responsible for proving each element of the original charge being brought against you beyond a reasonable doubt. You understand that? And you want to give those rights up, correct?
Yes.
Okay, you also have the right to see, hear, or question or cross-examine any witness called to testify against you, the right to call your own witnesses to your trial to testify on your behalf, the right to remain silent at trial and not have it be used against you, or you can waive silence and testify at your own trial if you'd like. You understand those rights that you would have to give up? Is there anyone forcing you to get you to give these rights up today?
No.
Anybody coercing you to get you to plead guilty? All right, and any promises if you plead guilty? Are you currently on probation or on parole?
No.
You understand that by pleading guilty, it could result in the conviction that you may need to report to your current employer, or you may need to put this conviction on a future job application. It also could have impact on where you can travel or get immigration status. So you may one day want to go out the country on a vacation, and they could deny you entry because of a conviction, criminal conviction. You understand that?
Yes.
And are you looking to plead guilty to the amended charge because you believe you are guilty?
Yes.
As to the amended charge of domestic violence, how do you plead? Factual basis, counsel.
Thank you, Your Honor. Mr. Green, is it true that on or about May 15th, 2025, you were present at or near 3606 Jerry Street?
Yes.
And is that in the city of Lansing, Indian County, Michigan?
Yes.
And is it true that at that time you were also present with a child with the first initial I?
Yes.
And is it true that while you're present with that child, there was an altercation of some kind?
Yes.
And you did offensively touch him or attempt to offensively touch him
Yes.
in a way that he did not want?
Yes.
And I believe that satisfies the factual basis.
Any questions from the prosecution?
Just one. Mr. Green, was the child with the first initial I, was that your biological son?
Yes.
Okay, thank you. The people are satisfied. Factual basis.
The court will find the factual basis sufficient. I accept your plea. I find your plea to be freely, voluntarily, and intelligently made. This matter is scheduled for sentencing on February 3rd at 9 o'clock in the morning. When you leave here today, you need to go downstairs to our probation department. We will check in with them so that they can get you scheduled for a pre-sentence interview. You also will be required to undergo a substance abuse assessment. And they'll advise the court as to how they believe you should appropriately be sentenced, okay? You have any questions for the court at this time? So, you'll have at least 2 appointments from here. One is going to be a pre-sentence interview. The second one is a substance abuse assessment. You need to be compliant because when you come back here on February 3rd, I must have a report from probation. And that means they had to have gotten the substance abuse assessment from or completed in order to do that, okay? If you're not going to be compliant at this point, then it's going to send a message to me that you're not going to be compliant on probation. Do you understand that? I will dismiss the PA 53. Any additional matters for the record?
Nothing from the people.
Nothing further, Your Honor. Thank you.
So we'll get you downstairs, so.
Judge, just a FYI. I'll go down.
On the record in the matter, we took care of Matthew already, correct?
Yeah.
On the matter of the people of the state of Michigan versus, is Kevin Kemp in custody? Kevin Kemp is in custody?
Yeah, is he in the breakout room, Judge? I can't, I'm not.
Was that the jail?
Yeah.
He's there. Are you Mr. Kemp?
Good.
Okay, this is file number 23-00835, appearance, please.
Anna Buckingham for the people.
Jessica Strong from the Ingham County Public Defender's Office on behalf of Mr. Kent, who is here via Zoom.
Okay, Mr. Kemp was scheduled today for final pre-trial. This is for embezzlement. Do we have a witness here?
We do, Your Honor.
Is there an offer extended on this?
There was, Your Honor. The people have extended an offer for a plea, a payment restitution of $200 with a recommendation of no upfront jail.
I'm sorry, plea what?
A plea of guilty for the embezzlement charge and a payment of restitution to the victims with a recommendation.
These are not offers. We are aware of that. You can't offer for them to plead guilty and pay the restitution. That's not an offer. They already know that's the option. So there's no offer, correct?
Well, Your Honor, Mr. Kemp is actually okay with what has been offered to him today. He's been in jail since September 15th, and he's already served almost the maximum time for this crime. His interest is in being released today.
Recognize that could be his interest.
Sure.
What is his interest as it relates to the charge? He wants to plead guilty and pay restitution?
Yes, Your Honor.
We have a victim here today, correct, as well? Okay. Mr. Kemp, you want to plead guilty to the embezzlement charge?
Yes, ma'am.
Okay, raise your right hand, please. Raise your right hand.
Sorry.
Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury?
Yes.
You can put your hand down. Okay, Mr. Kemp, you have the right in this matter to proceed to a jury trial, the right to the presumption that you're innocent. So you're innocent until the prosecution can prove your guilt beyond a reasonable doubt at a jury trial. You want to waive that presumption and plead guilty?
Yes, I do.
Okay, you understand that that means you're also waiving your right to see, hear, or question any witness called to testify against you, the right to call your own witnesses, and the right to present evidence to show a defense of this charge?
I do.
I can hear you.
Yes, I do.
Okay, anyone forcing you or threatening you to get you to waive these rights?
No, no, Your Honor.
Any promises being extended to you if you plead guilty? Any promises to get you to plead guilty?
No, Your Honor.
Are you on probation or on parole?
No.
You understand that by pleading guilty, it could result in the conviction that you may need to put on your future job application, or you may need to report it to your current employer.
Yes, Your Honor.
It also could have an impact on where you can get a travel or immigration status. You understand that? As to the embezzlement charge, how do you plead?
I saw him mouth it, but it didn't.
How do you plead?
I plead guilty.
Is that because you believe you are guilty?
Yes, Your Honor.
Factual basis.
Mr. Kemp, were you in fact working at Subway between the dates of May 2022 and August 2022?
I was.
Was this Subway located on 2480 East Saginaw in the city of Lansing, the county of Ingham, and the state of Michigan?
So, yes,
And did you indeed take money from that location with the intent to convert it for your own use?
yes, I did. Yes, I did.
Is it true that you were able to take that money because you were employed at Subway?
Yes, I did. Yes, it's true.
Was the money that you took of the value of less than $200?
Yes, it was.
I think that satisfies the factual basis, Your Honor.
Any questions from the prosecution? Accept your plea or find your plea to be freely, voluntarily, and intelligently made. I'm assuming there's no objection to immediate sentencing.
Yeah.
Does your victim want to make a statement?
No, Your Honor.
How much is restitution?
$200.
I got it. Sorry. Keep going.
No problem.
Sorry.
Your Honor, may I approach with restitution?
Yes, thank you. I'm just waiting for his CCA. And then to we can make allocation.
Your Honor, Mr. Kim's greatest interest today is to take accountability for his actions. He is readily willing to do so. He is aware of the harm that he has caused the owners of Subway, the complaining witnesses in this case. He is also aware of the harm that it has caused his children. And above all, he would like to prioritize his reunion with his children and to realign with the values of being a contributing member of society. With that in mind, Your Honor, we would ask the court for mercy.
Does your client want to make a statement today?
Mr. Kemp, would you like to make a statement?
Take responsibility for my actions, and like I said, I take accountability for everything I did and everything I've done. Like I've been sitting in here 86 days, for what I have done, and I have learned a lot taking accountability for my actions. And that's all I have to say. That just sitting this time, I'll take accountability for my actions. And right now, I just want to do what I have to do, pay the restitution, get back to work, and do what I have to do as a parent.
What have you done what steps have you taken on your own to show the court that you've accepted accountability? Because taking or pleading to the charge after having served 86 days because you kept failing to appear and then you couldn't post a bond does not show me that you have taken accountability. It just shows me that you want it resolved so you can get out.
I say take accountability. I mean, like you hear while I'm in the jail, I have been taking classes. I have been learning how not to run from situations, and I just learned like running is not the best thing to do, and I take accountability for that. Like I'm not justifying anything you said. I take everything you said the right way, and I accept it. I have no excuse for that, but I have been doing way better like just knowing what I'm supposed to do and not do.
For your sake, I hope that what you're saying rings true. I'm looking at your criminal history. It's not good. It's largely assaultive in nature, with at least one other conviction similar in nature that was dismissed, but multiple violent convictions. You're gonna need to get yourself together, sir. You're way too beyond the threshold of age for you to not be able to have control over yourself and over the actions that you take. You're sitting in jail for 86 days for $200. It's foolishness. That's ridiculous.
That's
You're a
your
grown man. You need to get yourself together. I'm gonna credit you time served, because you have already served just about the max penalty I can impose on this anyways, outside of putting you on probation, and I don't see that as being meaningful. This is from 2023. We're going into 2026. There's a restitution amount of $200 that will be assessed, a fine of $200 that will be assessed, $75 crime victim rights fee will be assessed, and $50 state minimum cost. I expect that paid within 30 days.
sure.
What's your address?
My address is 339 East Edgewood Boulevard, apartment 789.
And what's your phone number?
Phone number is 57299-3712.
Okay, you need to make that sure that's paid within 30 days to avoid a bench warrant. Any additional matters for the record?
Yes, Your Honor.
You're all set.
Excuse me,
Yes,
to leave today?
yeah, you're all set on this unless you're being held by some other charge. I don't know.
Thank you.
You're welcome. On the record in the matter of the state of Michigan versus Tyrone Plummer, I have 25-01667 appearances.
Anna Buckingham for the people.
Jessica Straub from the Eaton County Public Defender's Office on behalf of Mr. Plummer, who is approaching. And now standing to my left.
Thank you. Mr. Plummer was scheduled today for a pre-trial for assault and battery, and then there was a contempt of court, a PA 53 hearing. How are we proceeding?
Your Honor, it's my understanding we were set for a final pretrial, but we do have the victim here and present, and so we would ask to set for trial. I believe that's all we have from the people.
What are we doing about bond violation?
Honor, the people would defer to the court.
The victim is here?
Yes, Your Honor, it's the same victim.
It's get to refer to me, it's referring to him. Is he gonna plea or are we having a hearing?
No one's talked to me, so I don't.
You mean no one's talked to you? Do you
I
have,
don't know what's going
do you have
on.
an attorney?
I haven't been able to connect with him this morning, Your Honor.
He's been sitting in my courtroom since I've been here. So I don't know what that's all about. You have a, but you were, this is not the first time you've been advised that you had a bond violation. You were arraigned on it.
Yeah, I was arraigned this.
Yeah.
And then
The
this
violation is that you had contempt, that you had violation, a contact with the protected party in violation of the no contact order. Are you pleading guilty to that or are we having a hearing?
You contact them.
The violate, I'm gonna read it to you again, because you already pled not guilty to this back in August, it looks like.
But
And
not
we
guilty
reset-
to something bad.
Yeah, but then you were arraigned by Magistrate Milmore for a bond violation, which you were arrested for.
Yeah.
The violations that on August 18th at 520 Cherry Street, that you allegedly walked up to Gregory Graham, and you approached him at the Justice in Mental Health and initiated contact with him, and to which his response was, "You're not supposed to be around me." That the police later were called and that you were arrested and lodged at the detention center, which you were arraigned on this by Magistrate Milmore. There was a not guilty plea entered. Are you pleading guilty today?
No,
Or are we having a hearing today?
I'm not pleading guilty. I'd rather talk to my attorney about
Talking to your attorney about it's not gonna change. If you're not pleading guilty, I'm calling the witness right now.
it.
You can have, you can call the
Please stop
witness.
talking to me. That's
sorry?
why they give me a bond.
Excuse me?
I said, please stop please stop being around me because we have a court date and.
The police stop being around you?
No, I
No, he
Oh.
I asked-
approached the complaining witness, Your Honor, at a resource for homeless people, and informed the witness that they're not supposed to have contact.
need to
So his
talk to-
contact is essentially him trying to comply with this no contact order.
I said, please stop coming around me because you know you're not supposed to be around me because you said it's a bond.
Who was
And he
the,
keeps
who was
coming
the
around me.
victim?
Mr. Gregory Graham, Your Honor, I'd be happy to call him in if you.
You can call him. Thank you. You can have a seat, sir. You can have a seat, unfold your arms and have a seat right there.
Still. Probably there. She works there. Now, it's Terry, he works there. Please don't ask him to. And they blew me over. They didn't say nothing. So I went up to my police guard, stay with me. And he said, "No, be before him, watch outside on the sidewalk, call the police and they came over and while sleeping."
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do.
You can have a seat. State your first and last name and spell both.
Gregory Graham,
Spell both.
sorry.
Spell your name.
Oh, I'm sorry. Gregory, Gregory, Graham,
Proceed, counsel.
Mr. Graham, on August 18 of 2025, do you recall coming into contact with Mr. Plummer?
Yes,
And do you see Mr. Plummer in the room right now?
yes, he's seated in the defendant's stand.
Okay. And on that date, do you remember where you were?
I was at the Jim Ho Drop-In Center on Cherry Street downtown.
Okay, and how What was your contact with Mr. Plummer?
I was first accused and then attacked by Mr. Plummer.
And what did he say to you?
He was accusing several people at the gym hall that he was accusing people of stealing a phone.
Okay, and did he come up to you individually?
Yes,
Okay, and is that the first time that he had come up to you?
I had had no previous.
This was on the
contact with
18th of
him.
August.
No.
I want to know what happened on the 18th of August.
This is the 18th. Oh. Okay. So, Mr. Graham, we're actually gonna, if I could point your attention to the more recent incident. Have you had contact with Mr. Plummer since the incident you're discussing?
Yes, Mr. Plummer has on repeated occasions violated the PA 54 order.
What occasions are you referring to?
There was one incident that I reported at Crystal Ray. And then there was another incident that I reported at, I believe it was at Jim Hall as well.
Can you tell me about that second incident?
The one at Jim Hall?
Yes.
Yeah, you know, it's a no contact order. Mr. Palmer wanted to continue to come up and have contact with me in a very aggressive fashion, very belligerent fashion.
Do you recall anything particular he said to you?
He kept saying that I needed to stay away from him, and I tried to explain to him that's not how a PA 54 works.
And at that time, did you reach out to law enforcement?
Yes.
And what was, do you recall what the demeanor of Mr. Plummer on that day?
Just agitated, hostile, belligerent.
Was he yelling at you? What was his tone?
It wasn't that loud, but it was definitely an aggressive tone with a slightly raised voice, body language, everything was aggressive.
Was it your perception that he was mad at you on that date?
I think Mr. Plummer is mad at everyone, but me specifically on that.
Okay. Your Honor, I have no further questions.
Any questions from the defense?
Yes, Your Honor.
Good morning.
Mr. Graham, what is Jim Ho?
It is a drop-in center for people who are then clients of any kind of support or psychological treatment. I go there because I have a diagnosis of post concussive disorder.
Is Jim Ho specifically your address? Is that where you live, sir?
No, it's a drop-in center. It's a day drop-in center.
So on any given day or time, you can't be sure who will be there. Is that true?
It is open to anyone who is a client of, usually through CMH.
On the day in question, I do believe that was August 18th, around 10 a.m. in the morning. Did you have an appointment at Jim Ho?
No, it's a drop-in center. It's open to free access of anyone who is, basically able to be there. You're not allowed to be there unless you're someone who has done some sort of treatment. In my case, I went to Holt Network after my concussions. That qualified for me to be present there. Anyone who is not a client of some sort of mental health or mental condition subsequent to injury, they have a lot of people that are there for head injuries. And if you're not of that subset, then you're not allowed to be there. It's not open to all.
So it's a crucial resource center for anyone who's entitled to the services they provide.
It's a very convenient resource center. It's not crucial. I mean, it's just nice to have a place to go, and they try to keep it as a nice and friendly and safe place for everyone. Sometimes it doesn't work.
On the date in question around 10 a.m., did Mr. Plummer express to you his concerns about the no contact order?
No, it wasn't expressing concern. He was being hostile and telling me I had to get away from him. And I explained to him repeatedly, that's not how the PA 54 works. He has to avoid contact with me. I'm not incumbent on any of those.
So he was expressing concerns specifically about PA 53.
He had it completely misunderstood. He thought that I had to stay away from him. That's not how it works.
Is there any way he would have known that you would be at that location that day?
He knew that at that time I was there very regularly, yes.
But it's a drop-in location, so appointments aren't made.
Right.
Correct?
Correct.
Thank you.
Can you redirect?
Yes, and basically when you do that, basically,
Mr. Graham, is that justice and mental health? Is that in the city of Lansing?
Yes, it's on, I think it's 520 Cherry Street.
In the county of Bingham?
Yes.
Nothing. In the state of Michigan?
Yes.
Okay, nothing further, Your Honor.
Thank you. May this witness be excused?
Yes.
Thank you, sir. You may be excused. Any other witnesses for the prosecution?
No, Your Honor.
Is the defense calling a witness today?
No, Your Honor.
Okay, you can make argument.
I apologize.
Argument.
Your Honor, just from speaking to the victim, this has been an ongoing issue. They tend to cross paths due to the homelessness of both parties. However, this is an open area that the resources have to be accessible to our victim. It's the responsibility of the defendant to follow the PA 53. The fact that he went out of his way to go up to our victim in this case and assertively tell him that he needs to leave, he can't come to these different places. It's not acceptable. The history of the defendant would suggest this is going to be an ongoing issue. And that's really all I have, Your Honor.
Thank you.
Your Honor, we would just call attention to a couple of things. Even the people concede to the fact that Daniel, where this incident allegedly occurred, is a very limited resource for people like these two parties. It's not a place where they can know that each other will be there. And in fact, Mr. Plummer was there. If you look at the sign-up sheet, he says he was there first. In addition to that, we would argue that his behavior was not assaultive, it was not aggressive.
We can't argue that because we don't have anything on the record but his testimony. So that's not in the record.
Okay, understood, Your Honor. Along with the fact that these are very limited resources and each of them are entitled to be at JIMO, we would argue that it is not in fact a violation of the no contact order, but in fact it was absolutely an attempt to comply with the no contact order, probably not executed in the proper fashion, Your Honor. Very, very much so a misunderstanding in how to go about doing so.
Thank you.
Thank you for the first time.
No problem. Sir, I don't know how long he was in jail when he was arraigned on the bond violation. Looks like he received $1,000 personal recognizance bond. The concern that the court has is that Mr. Graham testified today, not just about this incident, but at least another incident that occurred where the no contact order has been violated by you, Mr. Plummer. The statements here, I don't disagree that you don't have a right to access these resources and that you don't need to access these resources just as much as maybe Mr. Graham needs to access these resources. That's why they're there. You're under treatment or supervision by the community mental health who wants you to get your treatment and get the help that you need. But we also want to make sure you are a complete and utter understanding. And I don't think that you have an issue with understanding that there's a no contact order. You went out of your way to approach him, which is that's where the violation happened.
That's where the violation happened.
Yeah, when you all ended up at the same place, I can understand that happened. You can go to Meyer and someone you're not supposed to be in contact with is there. Does that mean you walk up to them and tell them you can't be around me? Because no, the order is that you can't be around him. The order's for you. You understand that?
I do understand.
You cannot be around him. Do you understand that?
I do. Understand.
You cannot be around him. Do you understand that?
Do I? Yes.
You cannot be around him. Is that clear?
Yes.
So that means if you do end up in a place, let's say you both have an appointment and you're both there, you need to stay away from him. You're not to walk up to him to communicate in any form or fashion. That's your responsibility. If you violate that, then you go to jail.
Your Honor, I'm
Are you understanding? Is it digesting? You understand that?
Yeah.
I'm not asking you what happened in the past because you had an opportunity to testify and tell me, and you didn't.
don't.
Yeah, yes, I did. I just said, is there going to be any witnesses? You didn't take the stand under oath. So I don't want to hear about what happened then. Now we're moving forward. You understand that? I'm making sure that you understand your orders moving forward so that between now and your next court date, I don't have to put you in jail. Do you understand that?
Yes.
So if you are both at community mental health or you're both at, was it Jim Ho, and getting treatment, that, and he is there, that you know, I'm going to stay the furthest away from him as possible in this moment. And I'm not going to say anything. I'm not going to look his way. I'm going to stay away from him. That's your responsibility to be in control of your body and your actions. You understand that?
Yes.
Is that a problem for you?
No.
Okay. And so there's no questions you have about that?
I do have a question.
Okay, what's the question?
Okay, what am I supposed to do when I'm at Christopher and he never goes there. He showed up there.
Okay,
And, okay, I go to Jim Hall's, I go outside to smoke in the back where there's a smoking section there, and you can smoke in the front. He comes right back in the back where I'm at.
then you
So I go
leave.
to the
Then
front,
you
he
get
comes
to-
there.
Then you get to leave. Oh, you're saying he's following you?
Yes.
Well, then you have to leave.
Yeah.
That's what you have to do because you have to know that the order is for his protection, not yours.
He's
It's-
following
it-
me around.
Then you have to leave.
Okay.
You have to leave. And even if that means that you get your services, because you're not there to be outside taking a smoke break, you're there to get services and then you gotta go.
I'm homeless, I don't got nowhere to go. I do move around and take care of business and do things I'm supposed to.
I recognize that, but if he's coming into the space that you're in and putting, because you know what happens if you believe that he's following you back and forth, you're gonna get agitated and you're gonna say something.
No.
Yes, you will.
I
And so
tried that.
if you go to McDonald's and he's there, then you leave and go to Burger King.
I would.
Okay?
I would,
You understand that?
I would.
You stay away. You do not give him the opportunity to follow you. That's your responsibility.
Because Jim Holmes and acts from there and they tell him, and he shows up.
I don't know that
What am I
they're in
supposed
a
to do?
position to tell who's there, Kitty, and I'm positive they're not allowed to do that. I'm positive you can't call any place where people are getting services and treatment and say, hey, who's there?
You're not
You
supposed to.
can't, you can't. They can't. They'll lose their license. So that's not what's happening. You may believe that's what's happening. Sir, is that what you're doing?
Absolutely not. I've never followed him.
I would hope that you wouldn't want to follow someone who you're accusing assaulted you. I would hope not. Doesn't sound safe. And so if he sees you, he's gonna want to get as far away from you as possible, aren't you, sir?
Yep.
I would hope so. But you have the responsibility. The responsibility is on you, okay, sir? I'm going to credit you time served for the violation. We're going to move forward to a jury trial date where you need to appear in person, okay?
February 10th at 8 a.m.
February 10th at 8 a.m. in person at the court. You need to be on time, okay?
Yes, sir.
There's also the issue of communication with your attorney, because there's a reason why your attorney had to come in here today and not have had prior communication with you, except for the fact that you have not given her an opportunity to make that communication with you. Do you have a phone?
No.
Okay, so then if you don't have a phone, it's your responsibility to be in communication with your attorney, because she can't track you down. So she can give you a date, say, we're gonna meet on this date. You need to show up to where she is so you can meet her. You understand that? Because she can't find you, and she can't do what she needs to do to defend you the day of. But if you put her in that position, she doesn't have a choice. You understand that? So my expectation is you all will figure out today when you're gonna have your next communication. So it'd be your responsibility again to be in contact with her. She's not gonna go around Lansing looking for you, okay?
Right.
Showing up to court on the day of the next court date is only part of your responsibility. It's also your responsibility to make yourself available to your attorney prior to that, okay? And that's for your benefit. She can't help you formulate a defense if she can't talk to you beforehand, okay? Do you have any questions, sir?
Questions, but yes, I do. I've called and tried to contact and let them know that I'm at Jim Holmes and I'm gonna be there for an hour and a half, or whatever. I may be there all day waiting for a phone call. They do not agree. They don't tell them that I'm there and I'm there.
You think it's their responsibility to call you because you're at Jim Holmes for the day?
No, I said I've called the prosecuting attorneys to talk to them.
You can't talk to the prosecutor. You have an
I get an
attorney.
answer machine.
You can't talk to the prosecutor.
I mean, not the prosecutor. my
The public
attorney.
defender.
Yeah, my public.
Okay, your
Yeah.
public defender has a number and an email she's gonna give you to get in touch with her.
I was getting with him.
Okay, but she's now representing you.
Yeah.
So there's gonna be information that you're gonna be providing, so you can email her directly. You understand that?
Okay.
And so that doesn't mean though, because you're gonna be at Jim Ho on Thursday, that she's available. You see what she does for a living? She's at court. She doesn't get to decide her court schedule either. The court does.
I can't text.
You can send her an email.
An email. How do I do that when I don't get an email?
Go to the library and create an email
You have to
address.
have a phone number now. Homeless.
You have to have a phone number to get an
Yeah.
email account?
Yeah.
Since when?
Since, I guess forever, because I've been trying for a
To
long
get,
time.
you've been trying to get an email?
Yes.
And you go to community mental health and tell them you need to get an email account, have someone help you. You
No
not
one
need,
wants to give me the phone number, John.
it's
You
your,
gotta put a phone number in, and get a text back, and put that text in, and then I can get my Gmail account. I have a phone.
so
then.
you have a Gmail account?
No,
Oh, you're trying to get a Gmail is what you're saying.
I've been trying.
Got it. Okay. There's other emails that you can get other than Gmail. You
Try
know that?
AOL and I've tried 2 different places. They want a phone.
Okay, well, then the only other option you're gonna have is when you meet with your attorney today, you all need to set a date today. We're gonna meet on this date at this location. Because she can't guarantee that just because you're at Jim Ho, she's gonna be able to get in contact with you.
I'm a top tier.
Well, you're sitting right next to her today, I hope so. Okay, you all figure that out today. Any additional matters for the record?
Came from the people.
We'll see you February 10th at 8 a.m. Yes.
So then, the record of the thing, if he's so scared of me, he's gonna stay away from me.
You're gonna have
Then be around me, right?
You know,
You can't be around him. You do know that, right? You can't be around him.
So, since I'm homeless and I used to go outside of the range, because when they show up, do I have to do that
Mr. Plummer,
still?
you're gonna have to talk to your attorney.
You just have to not be around him. Whatever that requires, you need to deal with that. If that's gonna be an issue, then we can revoke your bond. And then that way I can ensure that you're not around him, if you can't figure it out, okay?
It's fine.
Thank you. State of Michigan versus Latoya Scott, 5-02296, appearance of
I'm sorry, did you say stop?
Scott? Latoya Scott?
And talk meeting for the people.
Victoria Scott.
Oh, Scott. I'm
I'm sorry, the twins. Oh, I apologize. I thought that was one of the dismissals this morning.
Was it?
It was.
Did I sign a dismissal?
I don't know if you signed it, Your Honor. I know we advised the court, but you were doing a couple of things, so I'm not sure what actually happened.
I don't think that's, okay, did no witness appeared
No, Your Honor.
here, and Scott's here?
I thought she was, Your Honor. Give me a second. I don't see her now, Your Honor.
You've not had contact with the
No, Your Honor.
victim?
No.
We'll enter dismissal.
Thank you, Your Honor.
State of Michigan versus Akila Thompson, 25-02756.
Haley Fortuna Gill on behalf of the people.
I'm gonna get in trouble.
Thank you. Parents for the record.
Haley Fortuna Gill on behalf of the people.
Kristen from the Ingham County Public Defender's Office on behalf of Ms. Thompson, who's standing to my right.
Ms. Thompson is scheduled for final pretrial today. This is for domestic violence. There was an offer for sentencing under 769.4A. To which your client declined. Did your client continue to decline that offer?
Yes.
Okay, so this matter is scheduled for jury trial January 6th at 8 o'clock in the morning. You must appear in person. The witness was here today, correct?
Yes, Your Honor.
January 6th at 8 a.m. In person at the court. Any additional matters for the record?
Yes, Your Honor. The people did receive a letter from the victim on this case. Yes. I did share that letter with defense counsel. The letter is essentially asking, the people were prepared today to ask that the defendant be able to have contact with their infant child through a third party. However, it's my understanding the defendant doesn't wish for that change. So I just wanted to place that on the record. That the people would be okay with that, but it's my understanding the defendant's not interested, so I suppose it's moved.
We don't object to the no contact order.
No contact order will continue as it is. Any additional matters for the record?
Not for the people, nothing further.
You're all set.
Thank you.
Oh,
State of Michigan versus Ezekiel Iran Kinjije. This is in file number 25-03472. Appearance, please.
Haley Fortuna Gill on behalf of the people.
And please, the court, David B. Carter Jr. on behalf of the defendant who is not present. I've called the hall several times. I have not heard from him.
Okay, had you had any contact with him prior to today?
No.
Okay, well, it's your bench warrant. And then you had a Stamper, you said?
Yes.
State of Michigan versus Amy Stamper, 25-02041. Appearance, please.
Stanford.
Haley Fortuna Gill on behalf of the people.
May it please the court, David B. Carter Jr. on behalf of Ms. Stanford, who is present and standing at council table.
Okay, today was the date that was scheduled for a pretrial. This is for 2 counts of assault and battery.
There was an offer, Your Honor. I believe an offer was conveyed. Excuse me. I believe an offer was conveyed by APA Joel Martinez to plead to count 1 and dismiss count 2. Okay. If that offer was not previously conveyed, I would convey it now on the record.
Thank you, Your Honor. I've discussed this matter with my client. She maintains her innocence in this. I would indicate to the court that I haven't gotten through the discovery because I guess when I sent in my appearance to the prosecutor's office, it had the wrong case number and that delayed things. Although I've gotten my client side of the story without reviewing the discovery in whole, it's hard for me to advise one way or the other, but she maintains her innocence at this time. So I don't know if the court would like to set it for a final pretrial or another pretrial.
Okay, you're still waiting for discovery, has it been sent?
It's
Oh, you
been
haven't,
sent.
oh, you haven't
I
gotten
haven't
through
gotten
it,
through
got it, okay. Let's see, I can set it for final pretrial.
Okay,
Final pretrial, January 6th at 8 AM.
And trial date, February 10th at 8 AM. Does that work for you, Mr. Clement?
did she say
January
February 10th?
6th, yeah, February 10th for
Yes,
trial.
both dates.
Okay, very good. So final pretrial will be January 6th in person at the court, 8 o'clock in the morning. February 10th, also at 8 o'clock in the morning in person at the court. Do you have any questions today, Ms. Stanford?
No, ma'am.
Okay, we'll get you notices to appear. You'll remain in contact with your attorney. Any additional matters for the record, counsel?
Not for the people.
Not for the defense.
Thank you, you're all set.
Thank you, Your Honor.
State of Michigan versus Anthony Clark, 25-01587. Appearance, please.
Haley Fortuna Gill on behalf of the people.
Anthony Clark's not here.
I don't believe so, Your Honor. Nobody by that name has spoken with me or Ms. Buckingham this morning.
Oh, sure, benchmark. State of Michigan versus Henry Griffin. I have 25-02209, 25-02210, 25456788093. Appearance, please.
Haley Fortuna Gill on behalf of the people.
Mr. Griffin is on Zoom. Can you hear us?
Yes, ma'am.
If you start your video, please.
Your Honor, at this time, I would defer to defense counsel.
Well, Your Honor, we are going to ask for additional time. If we could set final pretrial.
Final
Mr.
pretrial on a expired plate, no ops, and let's see. For what reason? First of all, I know Mr. Griffin is not on my court with a do-rag on his head.
Mr. Griffin, take up the
Let's see. This was a matter back in September. He was working to resolve some issues. Said defendant had a city case with similar issues. And so we're still working to resolve. Is that what the issue is?
Yes, Your Honor. So he has actually progressed. He has taken the driving test, as I understand it, twice now, and he has not passed. And so he is looking to take it for a third time. And so that's what we're asking for time for, us to get the time to pass that test.
And when is he intending to take the test?
I go tomorrow again. I go tomorrow at 11:40.
January 6th at 10. January 6th at 10 a.m.
Yes, ma'am.
The last reset on that one, and we'll reset the expired plate and the security as well. Do you have any questions today?
No, ma'am.
Any additional matters?
Not for the people, Your Honor.
Nothing further, Your Honor. You're all set, sir. Jordan Dotson today? No? Amy Smith? Not here. Thank you. Oh, big short goal for failure to pay. Let's see, is Dominique Delafonte here? No? There's no public comment or reading on that one. Joshua Vogel here? Joshua Vogel. Mr. Riley is representing Vogel. Oh, you are, have you had contact with Joshua Vogel?
I tried to make contact last week, Your Honor, but did not receive a return phone call.
Yeah, we should have been trying. Mr. Dunn, you know this was to be here?
Or the section of waiting.
Five people. That's interesting. That's it. Oh, I probably should have read you all.
I need to call.
Let's see. I don't know what's going on. Legal services is here on which matter?
For the motion to set aside for Stephen Newton.
Oh, it showed up differently on that. It just showed up as a motion. Yeah, let me make it effective. I see legal services, are you present? You're muted.
Hi, Your Honor.
Hi, is your client in person or?
Yes, he is. He's in person, Your Honor.
Stephen Newton here? Oh, okay, on the record in the matter of the state of Michigan versus Stephen Newton 20-00402. Council appearance, please.
Yeah, if I can hear from people.
Rebecca Nybert, serving on behalf of Legal Services of South Central Michigan and Mr. Stephen Newton. Mr. Newton, can you state your name for the record, please?
Stephen Newton.
Okay, today was the date scheduled for a motion to set aside a conviction. Just trying to review the file, I don't see. Okay, we did have something from the Office of the Attorney General indicating that the defendant may be eligible to set aside said conviction and that they had no objection. Is the prosecution making an objection at this time?
Oh, Your Honor.
Okay, counsel, you can address the court.
Thank you, Your Honor. At this time, Mr. Newton has not been convicted of more than 3 felonies. He has not been convicted for assault of crime to be set aside during his lifetime. He has no criminal charges pending against him. He has not been convicted of any criminal offense during the applicable time period required, which here would be 3 years. 3 years have passed. And as you understand and saw, that opportunity has been given to the Attorney General and the prosecuting official. And we do believe that circumstances and behavior of the applicant from the date of the applicant's conviction just warrant setting aside the conviction and is consistent with the public welfare.
What has your client been doing since the time of this conviction?
Thank you. Yes, Your Honor. He is a genuinely dedicated individual and a go-getter. He is someone who values education and hard work. He achieved his GED, then earned a degree in residence building from Lansing Community College. And for the past 4 years, he has been successfully owning his own and operating his own home building business, which he finds incredibly rewarding. In his personal life, Stephen has raised 3 children, and 4 children, I'm sorry. And then he has a current child that's 3-year-old toddler at home. So quite a significant age span. But he is also a responsible homeowner who enjoys tinkering around the house and assisting his friends and family with any work that they might need help with. His primary goal is to have this conviction expunged from his record because he believes that this might help him advertise a clean record to potential new customers, as well as significantly help his business to thrive. Therefore, we're asking you, Your Honor, and this honorable court to grant this application for expungement.
Did your client want to make a statement today?
No, Your Honor, I think she summed it up.
One of the first people I put on probation. Let's see here. See if you've had any interaction with the criminal justice system since then. It seems like you've made some serious life changes over the last 5 years.
I've cleaned my stuff up since the last 5 years.
Yeah, I don't see
No
any
other interactions.
I don't see a single interaction.
The last one was kind of a stupid one. Before then, it was a long time as well. So I'm hoping not to have any other interactions from this on. Why not?
Well, we'll declare that you won't do it because you're in control of your actions now. Whatever the underlying issue is, I hope you've addressed it. It appears that you are on a real positive trajectory. I think you reported even when you were on probation that you were working, but still running your own private business in carpentry. And so now it looks like you have, look, you were working at a box healing purchase. What was it? North Rec Box Healing and Purchases. Is that where you were working?
No, I don't remember. I don't think that was me. I've worked for Trumbull Builders for a very long time, where I went into the carpentry union, and then did a few years in the carpentry union. People were getting laid off and started my own business.
It's definitely you. That was from February 2020, though. When you were arraigned, where you reported your employment and that you were working as a carpenter since September.
Oh, Reckenbach.
Reckenbach. Okay, that's
Yes,
what it is.
yes,
Okay.
I'm sorry. That was the union company.
Got it. Okay, so but I'm happy to see that you're making changes and that you're cleaning up your criminal history. I don't see anything present. Counsel, did you have something you wanted to add?
Your Honor, yes, I'm sorry for the late disclosure. To have it on the record, I do see a pending from February of this year, unlicensed dog, vicious tendencies and dog at large. I felt that I needed to make that clear on the record. I wouldn't want that to withhold Mr. Newton from being able to proceed.
I'm positive that his dog at large.
Yes.
And unlicensed dog will not do that. And I'm sure that there are other ways that he can resolve that matter outside of the conviction. So we should probably work on that. Very good. Again, I have heard of both statements made by you and your attorney. I think that the circumstances and your behavior do warrant setting aside the conviction as it's consistent with the public welfare. So I will grant your request and have that set aside. It'll be dated assigned for today. So congratulations to you, sir.
Thank you.
Any additional matters for the record, council?
From the people.
Thank you. You're awesome.
Thanks. Have a great day, Your Honor.
Same to you. Mr. Dunwoody Moore has a review.
Yes, I'm here.
On the record in the matter of the state of Michigan versus Marion Dunwoody Moore 23-00839. I do see Mr. Hannah is present. Boy, oh boy. Let me check my email because I missed, of course, if you think I remember anything that happened last week, I don't. What are we doing today, Mr. Hannah?
Marianne, we just spoke over the phone about 30 minutes ago. He told me he graduated the GED program. I believe he just wanted to just talk with him and just give him congratulations, and I can discharge him afterwards.
Oh, okay. So I think that what we were waiting for, at least that's my last notice, that he was supposed to be finishing his GED program, with MRT and enrollment at CMH. Everything else I think he's been compliant with. And we were just waiting on that compliance with the GED. So you graduated, Mr. Dunwoody Moore?
Yes, ma'am. And I would just like to say that I appreciate you so much, because without you sitting me down and having to do this, I don't feel like, me personally, I don't feel like I would have went back and did it. But now that I've seen that I did, I even think that I had a tour at LCC on Friday, and they asked me what did I want to major in, and I told them culinary classes, so I can get my own food truck running up, and they told me they can help me with that. So I just want to say I thank you so much.
That's amazing. Congratulations to you. Mr. Moore, Dunwoody Moore, you and I have come a long way, okay?
Yes, ma'am.
A long way. This is not the first time you've been on probation before me. And the first time it was very touchy. It was in the middle of COVID. I remember your dad chiming in and cursing me out, I believe, and I had to redirect him. He told me,
yes,
he essentially assumed that because I sit from this vantage point now, that I had no understanding of what it would be like, being raised in a single parent. I had to redirect him. You don't know anything about me, and you're completely inaccurate about your assessment. And that it was important to hold you responsible. You were a young father then. And it was clear you had potential. It was just about you deciding that you were going to separate yourself from whatever action or influences that were causing you to engage in the nefarious activities that you were engaging in. And I would say over the course of the last few years, you've really proven yourself to be maturing. Mr. Hannah has been so proud of you. He's given me updates on your status along the way. And then here you are graduating and now hopefully going into some entrepreneurial business. So I wish you all the best in your future endeavors. I am happy to see that our relationship here, as you being a probationer of mine, is going to terminate today successfully. And you will no longer be not only under my supervision, but hopefully in the future you will no longer be under any court supervision. Okay?
Yes, ma'am. Yes, ma'am. And I just want to thank Mr. Hannah and also you, Judge, for helping me take that step to maturing and growing up and becoming a man that I needed to be for my son.
I'm happy to hear that you made my day, sir. So congratulations and best wishes to you, okay?
Thank you so much.
Thank you. Thank you, Mr.
Yes,
Hannah.
Brian. Have a good rest of your day, Judge.
Same to you. Okay, let's see. Can I get my docket? On the record in the matter of the state of Michigan versus Aiden Mosher, 25-01695. Appearance, please.
And a Buckingham for the people.
Good morning, Mayor. Please, Honorable Court, Kareem Johnson on behalf of Mr. Mosher stands to my immediate right.
This matter was scheduled for jury trial this morning.
No, we were here.
No, you weren't.
I was here at 8 a.m. 8:08 a.m. When I got here, my client was here. I checked in with the court, let them know we were ready for trial.
I called the hallway 3 times with him. He went in the hallway. I yelled with a couple people. He never, what I was told was that he was downstairs in the lobby, but he wasn't up here.
Who was in the lobby?
From what prosecutor told me, Mr. Motion was down in the lobby, but that was far after I had called his name.
Yeah, no one was here. The administration is not calling a jury trial or jury in when we don't see defendants, and your names were called multiple times. I was told you were at a different court.
Yes, I got called across the street to address a matter of a homicide.
How are we calling a jury and you're not here?
And I was here. I was told to be here 8 o'clock. I was here 8 o'clock.
Mr. Johnson came, then Mr. Johnson came, Mr. Johnson left because I called security to stop me before he walked out the building. He did come in this morning, but after that he left. But we did call security to say, can you stop him? But on his way out, you gotta stop him.
Correct. And so I asked multiple times, is the client here? He didn't respond. He was not on this hallway, so he wasn't at the court. The court is the 6th floor.
Now, when I got to the 6th floor, I wasn't here. I don't know what happened when his name was called. When I got here at 8:08 in the morning, him and his entire family were here, sitting in the hallway, ready to go. They were actually not too far from the complainant.
And you told my staff you were ready for trial.
Yeah.
That was not what was communicated to me.
Trial suit and everything, ready to go. Pink suit.
I called the hall. I seen you, you're right. I
Yeah.
seen you. I called multiple times. Remember around that time you were here. He was not in the hallway.
Well, I don't know if he went to the bathroom, if he went to go get some drink.
We didn't call just one time. It was multiple times.
What I do know is that when I walked in here this morning, he was here with the entire family, ready to go.
And where were they when you left?
When I left, they were in the hallway over there by the elevators.
No, they weren't. They would have heard his name being called. Sir, you raising your hand?
He did indicate he did go to the restroom. And there's no restroom on the floor, so he's got to go down to the.
But it wasn't just a one-time name call that took place. It was multiple names. Multiple times his name was called.
And security came down to get him while he was down at the restroom and get something to drink.
Again, the policy of the court is all parties have to be here, not just you check in at 8 o'clock and then you get to leave. We don't know if you're gonna make it back. You could be walking across the street and get accosted for all I know. I don't know. We're not calling in a jury if you're not here. And the jury doesn't get called in until 9. So if we don't see you here, the jury can't get called in. And then I was told you weren't here, so I issued a bench warrant to remand you for not coming to court. Here, this is where you're supposed to be. And if you need to step away for some reason, you let my staff know. If you gotta go put money in your meter, if you gotta go to the restroom, so that you're not assumed to be missing or not here, okay? This matter has to now be reset for trial. Did you say that was your trial suit? Is that what you said?
Yes, sir.
Okay.
You can do January 6th at 8.
And of course, this is not the priority, correct?
It would be.
Oh, okay, January 6th works for you?
No, it does not, Your Honor.
Okay. That's fine.
February 10th at 8 a.m.
That work?
Yes, Your Honor, it does.
February 10th, 8 o'clock in the morning in person at the court. It's not priority. It is not the priority case that day, though. So, Mr. Johnson, if you want to check in with the court closer to that date to see if the other one's expected to go, because the policy of the court is that the prosecution must let us know the Friday before if we're calling in a jury. So if they've not let us know that the other one's gonna go, then your case will be going. Okay,
I will stick with record. Our case is going. We are ready to go.
very good. Any additional matters for the record?
No, Your Honor, thank you.
Thank you, you're all set. Wait, Scott. Someone tell her to log in. Or something. I thought I handed Latoya Scott. Latoya Scott? Did you tell your client to log in?
I did, Your Honor, in between. I sent the text as you were asking me if she was here. because she-
Oh, okay,
and
she's
so
logged in.
back
Ms. Scott, we dismissed your matter without prejudice, so that means that the people do have the right to reissue that against you, okay?
Yes, ma'am. Thank you so much, Judge, Your Honor.
You're all set.
Thank you so much. Have a great afternoon. I apologize for being late. Happy holidays.
Same to you. Okay, let's see.
Yeah, was I quickly advised that Bonds had a benchmark issue? That was Vogel. It was Vogel. Okay. I was like, this one's in here.
I was gonna say Bellefonte. Where's Bellefonte? Okay. Oh, it's Jim. Oh, I think I actually crossed it out. State of Michigan versus Dominique Bellefonte, 25-3267, appearance, please.
Anna Buckingham for the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Elephant joins us via Zoom.
Okay, today was the date and the time that was scheduled for a pretrial. This is for a domestic violence.
That's correct, Your Honor.
How are we proceeding? Is there an offer at all?
No, Your Honor, not yet. We would ask for this to set their final pretrial to have further discussions.
Oh, deeper.
Final pretrial January 6th at 8 a.m. Jury trial February 10th at 8 a.m.
Okay, Ms. Bellefonte, you must appear in person at the court January 6th, 8 o'clock in the morning. And then you have a jury trial scheduled February 10th in person at the court, also at 8 o'clock in the morning, okay? You're muted, so I didn't hear any response. Did you get those dates? Okay, something's going on with your volume, but it sounds like you said yes. Okay.
And I'll stipulate that she is nodding her head, yes.
Any questions for the court today? If you have a question, put your thumbs up. If you don't have a question, you do have a question? You're gonna probably have to type it in the chat because we can't hear you.
If it's a question about your case, you can always shoot me an email as well. If it's a question about court, put it in the Zoom chat. Yeah.
Okay. She said she's okay. Okay, so no questions. We'll see you in person at your next court date. If you do have a question, just reach out to your attorney. Any additional matters for the record, counsel?
Not from the people. Nothing further. Thank you.
Thank you. You're all set. Ms. Sowers is here. Okay, on the record in the matter of the state of Michigan versus Coding Sowers, 25-01702. Appearance, please.
Anna Buckingham for the people. Jeff Straub from the Ingham County Public Defender's Office on behalf of Ms. Sowers, who is standing to my right.
Okay, Ms. Sowers has a unlicensed dog and a dog at large. How are we proceeding on this?
I haven't had a chance to talk to defense counsel, so I'll defer to they would like to do.
My understanding is that today's a pretrial, Your Honor. We would just simply ask to move to final pretrial.
Final pretrial for what? Purpose?
So we've not yet been able to receive an offer from the people.
I think the offer is typically that they resolve the issue when they discuss it.
There are some complexities with this case.
Let me guess, the dog is non-vax or what?
Yeah, it cannot be vaccinated
Oh.
because it's 18 years old.
Is this the same dog that we just had an issue with or a different dog?
Oh, it's the same dog, Your Honor.
Well, actually, I don't think it is.
We are contesting some of the identification of the dog, Your Honor, from the patient.
Got it. Okay, so we don't need a final pretrial, we just need another pretrial so you all can have time to try to work this out. It's a dog at large.
Gladly, Your Honor.
Yeah, so I can reset that so you all can work through the complexities.
January 6th at 10.
January 6th at 10. You said dog is over 18. Is that what you said? Yes, Your Honor. Any additional matters for the record?
Not from the people.
Nothing further, Your Honor.
Thank you. We'll get you a notice to appear. Okay, Ms. Owens?
Yes, Your Honor. Thank you.
You're welcome. Representing Elise Messiah.
I believe
Yes.
Messiah first.
Ms. who's? Okay, on the record.
I was just gonna say, Jones can go. That's the Nolly you just signed.
Jones, I just dismissed that. Is that
The
correct?
people dismissed it.
The people have dismissed yours, Mr. Jones. You're sideways too. I don't know why. But you're all set.
You talking to me?
I'm talking to you. Your case has been dismissed.
Thank you so much. Thank
You're
you,
welcome.
Your Honor. Thank you, the public defender. Thank you. Thank you also.
Welcome.
Thank you.
Have a great day.
Thank you. Okay, let's see here. On the record, in the matter of the state of Michigan versus Elise Messiah, 25-02048 and 25-02073. Appearances, please.
Anna Buckingham for the people. Jessica Straub on behalf of Elise.
Yes.
Very good. Both files are domestic violence files. Were there offers extended at this time?
Not at this time, Your Honor.
So final pretrials on both?
Yes.
Here.
Here? Can you hear us, ma'am?
Yes.
Okay, we're gonna set your matters for final pretrial. There has not been an offer extended for a plea deal at this time, okay?
Okay.
Final pretrial January 13th. Jury trial February 10th. Okay. Yeah. Okay, final pretrial in both matters will be January 13th. It's gonna be at 8 o'clock in the morning. You must appear in person. And then
Okay.
jury trial will be February 10th, also in person for both, okay?
Okay.
You have a question?
I'm new, like this is all new to me. So what's the jury trial? What is that?
Okay, so your jury trial, that's a great question. So you are innocent until proven guilty. That's your constitutional right. Do you understand that?
Yes, ma'am.
Okay, so you can maintain your innocence, which you've entered a plea of not guilty. You can maintain that. And
Okay.
you can take this matter to trial. At trial, the prosecutor would have to first prove that you're guilty by proving each element of domestic violence in each file. They have to prove them beyond a reasonable doubt before you would be considered guilty, okay? So if they're unable to prove it beyond a reasonable doubt, then you maintain your innocence and the case will be dismissed at trial. You understand that?
Yes, I do.
So you'll come and you'll meet with your attorney before then, so you go over evidence and possible defenses. And then if this matter is going to go to trial, you'll come in and you and your attorney will help you select a jury of your peers. So that'll be 6 people. That is, I can't, these chairs that are on the side of me, they'll sit there, they'll listen to the case. In a jury trial, the jury makes a decision about whether or not they believe beyond a reasonable doubt that you're guilty. Or if not, or if they don't, then it's a not guilty. And it has to be unanimous. So if one person doesn't believe that you're guilty beyond a reasonable doubt, then you're not guilty.
Okay.
all 6 of them would have to agree that they believe beyond a reasonable doubt that you would be guilty of domestic violence. Now, you have 2 separate cases here. Obviously, they're both not going to go to trial on the same date. Well, it looks like it's the same victim, but nonetheless, there may or may not be an offer extended at the final pretrial. The purpose of the final pretrial is for the court to determine whether or not we actually have a victim that's willing to participate in this matter. So that's why the court requires the victim to appear in person. If no victim appears, then the defense has the right to request to have the matter dismissed, but it's dismissed without prejudice, meaning that the prosecutor could request to have it reissued if the victim changes their mind. Now, the victim could appear and say, you know what, I'm here, but I don't want to proceed. The prosecutor is going to likely still want to proceed on this matter because sometimes victims feel like they're under duress or whatever the case may be. Your attorney can still make that request to have the motion to dismiss without prejudice if that victim appears and says they don't want to proceed in the matter. We have to have a victim that wants to proceed in order to go to that February 10th jury trial date, okay?
Okay, so the jury's February 10th and the final trial is January 13th, correct?
Right, that's the final pretrial is January 13th, and then the jury trial is scheduled for February 10th, okay?
Okay, thank you so much.
No problem. Do you have any other questions at this time?
No, Your Honor, you have a great day.
Same to you. We'll see you in person at your next court date.
Sounds good.
And then Ms. Sowers, you had a question, or were you looking for your attorney?
She's waiting for her to
Wonderful stuff for me. That's all I have until 1:30. Thank you.